Welcome to Florida's Wealthy Divorces, complex cases, expert advice.
Hello and welcome to Florida's Wealthiest Divorces, complex cases, expert advice with Stacy and Beaulieu-Fawcett. I am your host, Kevin Rosenquist, and today Stacy lends her expertise and gives us a sneak peek into high net worth and high conflict divorces in Florida. Known for her strategic approach to the most challenging cases, Stacy works with clients who require meticulous attention to detail and a fierce commitment to protecting their assets. In today's episode, we'll explore the unique challenges of divorce for the wealthy and uncover practical insights for navigating these complex situations. Stacy, so great to have you here. Thanks for being here.
Thank you. I appreciate it. I'm happy to be here.
So what typically are the most common reasons cited for divorces in these unique cases we are talking about today?
Oh, Kevin, everyone asks that question. Everyone wants to know why people get divorced, right? But the ones that we're talking about today, I have to say, and it's what everyone guesses, but infidelity. It's the infidelity, sometimes to the extent where there are entire other families with other sets of children in these cases because they can afford to do that and afford to hide the money that goes to support that family. So that seems to be the most common. What comes up also a lot is difficulty with children from other marriages. So you get that blended family, the remarriage, the children, trying to integrate those children is always very difficult, and people get so frustrated. It creates such a battle in the home that I would say is probably the number two most common reason for people getting divorced.
I have a family. I love my family. I do not want a second one. I don't know where do people find the time for that?
I know. That's what I think too. Life is challenging enough. Can you imagine running two families?
No, I cannot. No thanks. But I'm not rich enough to do that anyway, but still, I wouldn't want to. What are the most common pain points that your clients are facing in a high stakes, more complex divorce?
Yeah, the pain points are different for sure when we're dealing with the high stakes, high net worth families. They've got the money to litigate endlessly. So sometimes that is the biggest problem, is one side or the other wants to just wear the other side down, and they can afford to do that. Where if you're not dealing with high net worth, the thing that sometimes keeps people reasonable is the fact that this costs a lot of money.
Right.
It's not cheap. So when you're dealing with high net worth, that's gone. So now your new pain point is, well, if I can just run this person down emotionally, then I'll get what I want. And that unfortunately is the motivating factor. But some of the other pain points or bigger issues in these cases has to do with alimony. What people don't realize in Florida a lot of times is that alimony is there when one party is the breadwinner and the other party has the need to have some support to be able to maintain their lifestyle during the marriage. Now, the lifestyles we're talking about in this case are quite extravagant most of the time. If you're talking about a high-end lifestyle, a person is used to receiving a certain amount of money. But what people don't understand is when you receive significant assets in a divorce, you now have the ability to pay your own expenses. So a lot of times in these very high net worth divorces, even though there was one spouse who has no earnings, no job, they don't get alimony. And that is mind-blowing for a lot of people. But the reason is because if we settle your divorce and we have a $40 million estate and each spouse walks away, theoretically, this is supposed to be equitable, $20 million each. If you're sitting on $20 million, you have to assume that you're generating some sort of interest dividends from $20 million. It typically is enough to support the lifestyle, but people get very stuck on the fact that, well, I'm entitled to alimony. He has or she has a lot of money and I'm entitled to this lifestyle. Well, yes, but you also got assets significant enough to give you enough dividends and interest to support that lifestyle. Therefore, you don't get alimony. Big pill to swallow. People don't understand it. It's a big pill to swallow. Some of the other pain points have to do with really supporting that lifestyle. So even though the money is there to support the lifestyle, sometimes the lifestyle is viewed by our judiciary as too extravagant. Just because you're used to shopping and spending $10,000 a month on stuff, it's just your shopping budget, your clothes, your shoes, your handbags, etc. Some of our judges will look at that, even though that's the lifestyle, you're entitled to maintain the lifestyle. They'll say, you know what, it's too much. It's too much. They'll cut that back. That's a big pill for a lot of people to swallow as well. And on the other side of that, the person paying the alimony doesn't want to have to continue to support that lifestyle. Sometimes the lifestyle was even the problem in the marriage. Somebody may have a spouse who is a huge spender and just wants to live this lifestyle that the other side really is not interested in living, regardless of how much they're worth. So that it becomes a huge pain point that, what do you mean I have to continue to support this lifestyle that I never approved of during the marriage? And now I have to continue to support it, though I'm getting divorced.
Yeah. If you were not liking how much that person was spending in the first place, yeah, you don't want to keep that going just because you have it.
Right.
Right. Yeah.
Right.
Wow. Different problems than a lot of people have, for sure.
Absolutely. Absolutely.
What are some of the unique challenges you face when representing high net worth individuals in a divorce case?
Well, one of the unique things we kind of touched on already, but it's worth mentioning again, and that really has to do with the fact that the budget is endless, right? They're coming into this litigation with an ability to spend a limitless amount on the litigation. So that is one of the big challenges. They want to fight over principal. Well, when you have unlimited funds, you can spend a lot of money on principal, and you're really just fighting, right?
Right. Yeah. It's just not willing to budge. Yeah.
Right. And if people have limited resources, I can have a real conversation with them and say, listen, you're fighting over principal. This does not matter in the big scheme of things. Do you really want to spend this kind of money on this issue? And when we do that, then it normally, emotions are high. It normally brings people back to reality of, okay, yeah, you're right. I'm just being reactive, or I'm being emotional, and I don't really want to fight over that issue. Mm-hmm. But when you're dealing with someone with, and I say unlimited, but unlimited resources, principal becomes something they fight over a lot. And you can have in a divorce a lot of issues that they want to fight over the principal of it. So that is a big challenge, and just trying to constantly bring people back to their ultimate goals, and whether or not this fight over principal supports that long-term goal in the divorce. That's one of them. Other challenges, sometimes you have one spouse who controls all of the finances, and the other spouse has just been either given a credit card to live on or has been given an allowance, and they are wholly dependent upon the other spouse. So in the beginning of a divorce, a lot of times they're cut off financially. They don't even have the money to hire an attorney. So that presents obviously a problem, because now you've got a situation where the other spouse can just railroad them. Well, the statute accounts for that. Each person has a right to counsel of their choosing. And if together the marital income, so the other spouse's income, is enough to pay for those attorney's fees, then that spouse that didn't have the money has a right to have their fees paid by the breadwinner spouse. So if the husband is the breadwinner, the wife is cut off financially, she needs to be able to hire an attorney. The statute provides for what's called temporary relief. This is where we go in front of the judge and we say, he has the income, he has the assets, he needs to pay her fees so that she can have a fighting chance. The problem, though, even in that, is the fact that you don't just get one of those hearings right when the case starts. So it just becomes a practical problem for those that are divorcing and that might be able to, that might get cut off financially, is you got to plan a little bit. You have to save a little bit of money, or you have to get a credit card in your own name so that you can get started, so that you can live long enough to get to that hearing where the judge can address the problem. So it's a problem to work around. It's a problem. A lot of people are in that situation, but that's the solution to the problem. And on the other side, if I'm representing the spouse that is the breadwinner, I have to have a conversation with them about optics. How strategically is this going to look to the judge when we get there and the judge realizes you've completely cut her off and she has no money to afford attorney's fees in that situation?
Yeah, it's not a good look.
It's not. It's not. Judges aren't too happy about that. So normally the result of that hearing reflects the conduct of the breadwinner. It's just something to keep in mind. It's our job to advise our clients, good or bad, so that they understand the risks of some of the decisions.
Are there Like what percentage of the divorces are smooth and like not contentious, would you say? Is it because it feels like when you have that kind of net worth and that kind of money, it's harder for a smooth process to happen because there's more infighting. Is that fair, or is that just am I generalizing?
It is a fair statement. You know, the more money people have, of course, the more they're going to fight typically.
Right.
But there are certainly a large number of cases where the people are reasonable. You know, marital estates, 30, 40, 50, 60 million dollars. They know they have to divide it in half. They do not want this publicized. They do not want, to air their dirty laundry. When you have two people on the same page, as far as that goes, it's much easier. It's very smooth. We're able to sit down and work through the issues. Math doesn't lie. The numbers are there. You're supposed to divide it equitably, equally. It's not hard to do when emotions are out of the picture.
Mm-hmm. Yeah.
The problem is sometimes they're coming into these divorces, scorned, they've been cheated on. They're angry and they want their pound of flesh. So, and that crosses all lines of wealth, right? That goes from the very, very most wealthy to the least wealthy. It's a very painful realization to know that, your marriage has been a lie, you've been cheated on, you feel betrayed, you feel all of these things, and now you're angry. Somewhere in there, the anger comes out and then it shows up in the divorce. So if people can, once they realize the marriage is broken, the marriage is over, if before they start moving on and making poor decisions, if they can sit down and go ahead and start working through dissolving that marriage, they would save a fortune in fees and the stress of the litigation.
Stress, yeah, I was thinking that too.
Yeah, because as soon as you take the emotions out, you can think logically and you can get it done. The emotions come in, the logic goes out the window. You can't think so.
Yeah, everyone falls victim to that, no matter who you are. How does the divorce process change if you're dealing with significant business ownership or complex financial portfolios?
Sure. It changes quite a bit only because of the experts that you involve. So if we have businesses, if we even just have high income, we involve a forensic accountant, a business valuation expert who comes in, who will, for a business owner, income is difficult to calculate because it comes in many different forms. The forensic accountant will step in, calculate the income, value businesses, and sometimes that is 20, 30 businesses. Sometimes it's extensive commercial real estate portfolios. Sometimes it is family trusts and family businesses that the family never thought for a million years that someone was going to be digging forensically into their finances. But now there's a divorce and now they do. That's sometimes why when you have a big family business, they will insist on the family members getting prenups because they do not want the whole family business being opened up because, Sue or Joe are getting divorced. So it changes a lot because of the level of evaluation and valuation of the family's assets, income, things like that. And then in the alimony piece, if there's alimony, remember, that's based upon lifestyle during the marriage. How do we determine lifestyle? Well, believe it or not, Kevin, we go back and we look at 1, 2, maybe even 3 years of all the spending, and we categorize all of it. So this is what the forensic accountant is working on. How much did he or she spend on clothing each year? How much did they spend on vacations, dining out, gas? I mean, it becomes very, very detailed, but you have to establish that lifestyle because that's how you determine how much someone gets for alimony. It's a starting place for alimony. It's not the only way it's determined. But
wow, complicated. Well, in your experience, what are the most common mistakes that affluent individuals make during the proceedings of a divorce?
Yeah, it's normally the mistakes that people make are things that generate a lot of unnecessary litigation. So if they would just stop and ask their attorney before making big decisions, a lot of times we can prevent that. But those mistakes are things like trying to hide money. Unless you're in a cash business, okay, you got restaurant owners, you got dry cleaning owners, there's a lot of cash flowing through those businesses. So unless you're in a cash business, hiding money is not going to work because there's a paper trail. We're going to go through every statement. The forensic accountant is going to go through every statement, and every transfer out is going to be questioned, and every withdrawal is going to be questioned. So if you're moving or trying to hide large sums of money, and some people try to think that they're smart and, well, I'm going to transfer it to this bank and, Guadalupe or something. And it doesn't work out. There's a paper trail. So again, unless it's a cash business, and that there are ways that we deal with that as well. Hiding money is a really, really bad idea always, but you're not going to get away with it. And it's going to be found. And then it just creates more litigation. So now what are the forensic accountants doing? Well, they're tracing all this money, all of these withdrawals, all of this money that went missing or transferred. And sometimes they think they're smart and they'll transfer it 5 or 6 times thinking, oh, well, nobody will be able to follow that. Come on now.
These people do it for a living.
Exactly.
Yeah.
So moving or trying to hide money is a big mistake because it just drives up the costs. We've had people try to sell properties. They'll forge names at closings. They'll have notaries commit fraud and sell properties from under other people. It's all traceable. It's not.
Especially these days.
Right, exactly. So the other thing that I would say a mistake in a divorce, we kind of touched on it, but is going ahead and moving on, right? Bringing that a significant other, that girlfriend, that boyfriend into the picture before the divorce is final. And the reason that's a big mistake, it's not because the law cares about it. It's not because Florida has, rules about boyfriends, girlfriends. Florida's a no-fault state. They don't care if you had 30 affairs, have, 9 girlfriends, boyfriends, it doesn't matter. But if we drive those emotions up, then that other side is not going to be logical. They're not going to come to a reasonable settlement. They want their pound of flesh and they want to punish you. So if you want to avoid that, then just keep everything at bay until the divorce is final. When the divorce is final, you want to bring the new girlfriend, boyfriend into the picture, introduce to the kids. That's up to you. That's fine. But in the meantime, when it happens, I get the call of the emotional client who now wants a pound of flesh. So it's a mistake. It creates problems. If you don't care about the problems, go for it. You're going to spend a lot of money on it though.
That's a really good tip. Like, just wait, just don't bring them around. Just keep them, keep them hidden to some degree. Yeah, that makes a lot of sense. So how about when children are involved? Speaking of that, how do you manage custody and support issues in divorces with high net worth families?
Custody really, it depends, right? Florida is a state that looks at both parents as being equal parents. So each parent is entitled to equal time with the child. In a lot of these cases, you're dealing with parties who have multiple homes in multiple states. So when the divorce comes, it's almost invariably one person would much prefer to live in the other state and the other parent wants to stay in which state. So a lot of, we're dealing with a lot of times New York or, wherever, Chicago, Maine, people that want to spend their summers in Maine, but you go to get divorced and now you decided, well, I want to stay in the New York property. I don't want to live in Florida. I never liked Florida. He or she always wanted to live in Florida. So it brings a different level because children are supposed to be able to stay generically and just being general where it is that their primary residence was. But when we're dealing with high net worth families, primary residence can be in 2 and 3 places. Now, what do we do? Now, where do the children stay? And if we're going to have parents in 2 different states, you can see what happens to the time sharing then. We don't have 2 parents who can have equal time sharing anymore. They're in 2 different states. So if the kids are in any in-person school, that's not going to work. Right. You can't equal in New York and equal in Florida when your kids go to school, St. Andrews. It doesn't work. Some of the kids have their own personal teachers and they're homeschooled, and that's fine. You can do that. We have kids traveling all over the country and international for time sharing. But it's the school that becomes the problem. Where do they go to school? So a lot of times if they are in school in Florida, we're able to keep them in Florida. It doesn't mean they won't still spend their summers in Maine or wherever it is that they're used to spending. But that time sharing dynamic, that piece of it, are both parents going to be in the same state, becomes critical. The other thing that becomes really important is the fact that if you have any safety concerns for the children, sometimes we have substance abuse allegations, sometimes we have emotional abuse allegations, and proving those things become really important. It's difficult to prove. If you don't have the money to be able to hire what's called a social investigator, which ends up being a forensic psychologist, to dive into the effect of emotional abuse, for example, and to really evaluate the children, do psychological testing on the parents, and dive into this forensically, not, oh, well, what does the child say, or what does mom say, or what does dad say, but to dive into the actual forensic side of it, then it's difficult to prove. You a lot of times end up with a child who continues to be at the abuser's home because you can't prove it. Emotional abuse is so hard to prove.
Yeah.
So families that have the money to afford a social investigation have the benefit of that professional diving in and making a recommendation as to how to best handle time sharing between the parents. Maybe one parent just really cannot emotionally manage themselves enough to be healthy with the children during a school week. It's just too stressful. I don't know. It triggers something in them. And in that situation, the forensic psychologist, after doing an investigation, would likely recommend that the children be with that parent only on the weekends instead of every day during the week when life is more stressful and you have homework and other things to commit to. So that is one of the bigger tools in our toolbox that we use when we have safety issues that not everyone can afford. It's an expensive process, just to get started typically is about $25,000 to the forensic psychologist. And that's just for that parenting piece. You've got your whole divorce case and your attorneys and everything else.
Yep.
Just the forensic psychologist to be retained is typically, there are different ones at different levels, but the ones you would want to use are about $25,000 retainer.
Wow. Well, certainly adds a whole layer of complexity, and we're gonna deep dive this in our next episode. So I'm excited for that. And well, thank you for tuning into Florida's Wealthy Divorces, Complex Cases, Expert Advice with Stacy Beaulieu-Fawcett. To connect with Stacy, head to blgfl.com, and please like and subscribe to our channel and leave us a review. Stacy, thanks so much for being here. I'm looking forward to the next one.
My pleasure, Kevin. Great to see you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.